Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. It has been said that if you like legislation and sausage, that you should not watch either one being made. Now, I've never watched sausage being made, but I'm sure there's a reason they say that. I have watched legislation being made, and I'm really certain you should see that. The problem with legislation is that everybody gets a voice. That's actually the benefit of legislation when you get right down to it. Every person in the state has a representative who, if they are doing their job, is advocating for their positions, their wishes, their beliefs in the legislative assembly. It has been said that if you like legislation and sausage, that you should not watch either one being made. Now, I've never watched sausage being made, but I'm sure there's a reason they say that. I have watched legislation being made, and I'm really certain you should see that. The problem with legislation is that everybody gets a voice. That's actually the benefit of legislation when you get right down to it. Every person in the state has a representative who, if they are doing their job, is advocating for their positions, their wishes, their beliefs in the legislative assembly. Today we have a case from Missouri that looks at a peculiar portion of their Constitution that requires that every bill that gets passed out of the legislature have one title and that the title fairly relate to the content of the bill. Now, the reason for this is that, as you may have guessed from watching the United States Congress work, not everything that comes out of legislation has a clear path. You will have things that get attached to spending bills that have nothing to do with spending in the U.S. Congress. You'll have things that have nothing to do with defense get attached to a defense bill. You'll have very favorite concerns of one particular legislator who happens to be powerful and can twist arms that get thrown into various bills in Congress, and that's how our United States Code has become so what I would call twisted and almost unrecognizable. But Missouri doesn't have that. And so let's look today at this case from the Missouri Supreme Court that deals with this single subject issue under the Missouri State Constitution. So here's the case. It's Jonathan Byrd et al. And the Gathering Tree doing business as Eden Village versus the state of Missouri. Appellants brought single subject, clear title, and original purpose challenges to the validity of the truly agreed and finally passed House Bill 1606 from 2022. The Circuit Court rejected these challenges and sustained respondents' motions for judgment on the pleadings. Appellants appeal, and this court has jurisdiction pursuant to Article 5, Section 3 of the Missouri Constitution, which, as most people don't know, it says that anything that is a constitutional challenge goes to the Missouri Supreme Court, unless that issue has been solved by the Missouri Supreme Court previously, in which case usually a lower appellate court is appropriate to handle something like that. But since this is the first time this has ever come up, it goes directly to the Missouri Supreme Court. And the Circuit Court's judgment is reversed. Now, this is what's interesting, the factual and procedural background. As originally proposed, HB 1606's title was An Act to Repeal Sections 50.800, 50.810, 50.815, 50.820, and to enact in lieu thereof two new sections relating to county financial statements. As originally introduced, 1606 sought to reduce the amount of information certain counties were required to publish in their financial statements. The House of Representatives passed a House Committee substitute for 1606, which merely changed the date by which these statements would have to be published. The Senate's Local Government and Elections Committee recommended that 1606 pass in the form of a Senate Committee substitute to the House substitute, which was titled An Act to Repeal 11 sections of the revised statutes of Missouri, and to enact in lieu thereof 9 new sections relating to county officials with penalty provisions. The Senate adopted a Senate substitute to this Senate committee substitute. The adopted changes include 1. Modifying the narrative title of the bill from relating to county officials to relating to political subdivisions, and 2. Adding Section 67.23 to the bill. This new Section 67.23, among its many provisions, sought to impose restrictions on the expenditure of state funds allocated for combating homelessness and make the act of unauthorized sleeping and camping on state-owned lands a Class C misdemeanor. The House refused to pass the Senate substitute, and the Senate refused to concede, so it went to a conference committee, and they passed out the final version of HB 1606. This final version included the new Section 6723 and 49 other new sections. In June, Governor Parsons signed the TAFB 1606 into law. In August and September, appellants filed separate petitions seeking declaratory and injunctive relief in the Circuit Court of Cole County, arguing that it violated the single subject, clear title, and original purpose requirements contained in Article 3, Sections 21 and 23 of the Missouri Constitution. And here is the Missouri Constitution, Article 3, Section 21, Style of Laws. It says it has to be opened in a certain way, and then it says no law shall be passed except by bill, and no bill shall be amended in its passage through either house as to change its original purpose. Bills may originate in either house and may be appended or rejected by the other. Every bill shall be read by title on 3 different days in each house. And then this is Section 23 of that constitutional provision, and here's what it says. No bill shall contain more than one subject which shall be clearly expressed in its title, except bills enacted under the third exception in Section 37 of this article, which isn't important here, and general appropriations bills which may embrace many various subjects. So it has to have a clear scope, and it has to be clearly expressed in the title. And so that's the 2 things that they sued upon. So the standard of review is de novo, meaning that they look at this brand new as if they were sitting at the circuit court, and they say if you attack the constitution of a bill, the burden is on you to show that it is unconstitutional, because a statute is presumed valid and it won't be held unconstitutional unless it clearly contravenes a constitutional provision. Appellants argue that in the inclusion of Section 67.23 in the truly agreed and finally passed HB 1606 violates the single subject requirement of Article 3, Section 23, because the provisions in this section do not fairly relate to HB 1606's subject of political subdivisions. This court agrees and holds that it violates the constitutional single subject requirement because the addition of 67.23 to the bill introduced at least one impermissible additional subject, that is, homelessness. Article 3, Section 23 provides that no bill shall contain more than one subject, which will be clearly expressed in its title. The test has always been a bill does not violate the single subject requirement so long as the matter is germane, connected, and congruous. In other words, the test for whether a bill addresses a single subject is not how the provisions relate to each other, but whether the provisions are germane to the general subject of the bill, which, as you know, was political subdivisions. This court looks first to the title of the bill to determine its subject. The bill's title is not too broad or amorphous to identify the single subject of the bill, then the bill's title serves as the touchstone for constitutional analysis. And here, this court looks to the challenge provisions to determine whether they fairly relate to or have a natural connection with or a means to accomplish the subject of the bill as expressed in its title. The subject of the bill was 50 new sections relating to political subdivisions with a delayed effective date for a certain section and with penalty provisions. Using TAFB's title as a touchstone, the subject of the bill was political subdivisions. Therefore, the primary inquiry is whether all of the provisions of the bill, including each of the provisions in the new section, fairly relate to, have a natural connection with, or are a means to accomplish the subject of political subdivisions. I will put a link in the description to where you can read this online, and I think you would find the case to be very well written. It explains it pretty clearly as to where the legislature went wrong. And then it says, having determined the inclusion violated one of the Constitution's bill passage requirements, the court must address the question of whether they are germane to political subdivisions, whether that can be severed, thereby saving the remaining portions of the bill, or whether the entire bill must be struck down. This court has said that when legislature violates one of the Constitution's procedural bill passage requirements, judicial severance will be appropriate only when this court is convinced beyond a reasonable doubt that the legislature would have passed the bill without additional provisions and that the provisions in question are not essential to the efficacy of the bill. And here they say both these inquiries seek to assure that the court that beyond a reasonable doubt the bill would have become law and will remain law even absent the procedural violation. Here the court holds there is no basis in the record for concluding beyond a reasonable doubt that the legislature would have passed 1606 without the new section. When the House initially passed 1606, its narrative title was relating to county financial statements. The substance of the bill was limited to repealing 4 sections and enacting 2 sections relating to that subject. So the Senate substitute had added 19 further amendments, and as a result, there's no way you can conclude that the bill would have passed in it as it was. So even though they enacted all of these other sections in this bill and changed the statutes as it was relating to those particular issues, because they screwed up with Section 6723, all of those are now constitutionally invalid under Missouri law. Now, what does that mean? Well, one of the things it means, and I think something that should be appreciated here, is that the court is holding the legislature's feet to the fire and saying, agree on a single subject, agree on the bill, pass clean legislation so that people can see who voted for what and why they voted for it. Can you imagine how much better our political discourse would be if in Washington, D.C., you couldn't log roll 19 different items into a bill, title it as a bill for defense contractors, and then, apply the bill to things like schools and roads and ports and boats and all other kinds of things. When you muddle up the process and you log roll all these different sections into it, a lot of times, to be fair, there are people who know everything that's in a bill that they're voting for in D.C., but most of the time, they absolutely do not, and they vote for stuff that they would not otherwise vote for, but they feel like they have to vote for it in order to get whatever specific thing it is in that bill that they want for their constituents. So again, my belief is that this is a really good part of the Missouri Constitution, and it's good because they saw a problem in how legislation was being done in other parts of the country. And when they drafted the Constitution for the state of Missouri, they said, no, we are not going to let log rolling of these bills happen. We're going to make sure that the voters know what the single subject of that bill is, what was in it, and who voted for it. So I would encourage you to go and read Sections 21 and Sections 23 of the Missouri Constitution. I will try and put the link to those in the description to this video as well. Do that, and I think what you will find is that they are very good ground rules for any legislature. And we ought to have a United States constitutional amendment that requires that to happen. Just my opinion. Be really interested in receiving your opinion on that. Please put your comments in the comments down below, or you can always email me at the address above. Thank you so much for watching. If you have the opportunity today, do something kind for someone. It'll make it a better day for everybody if you do that. Thank you again for watching. Come back tomorrow and catch me at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.